Hello friends, in the series on the income tax cases, today we will discuss a very burning issue on revision under section 263 by the Principal Commissioner of Income Tax. The general rule of doing revision under section 263 is that the order should be erroneous and prejudicial to the revenue. As far as the order is erroneous, there are some parameters which decide that whether an order is erroneous or not. In the present case, the ATIC deduction was given to the assessee for the substantial expansion at the rate of 100% for the assessment year 12-13, 13-14 and 14-15, but the CIT revised the order only for the assessment year 13-14. So the moot question is that when the ATIC deduction at the rate of 100% is given for the preceding year and the succeeding year, can the Commissioner revise the order for the assessment year 13-14 for non-giving the deduction under section ATIC at the rate of 100%? This issue has been decided in the case of C&E Limited versus Principal Commissioner of Income Tax, and this case has been reported in 460 ITR at page number 13. The matter has been decided by Calcutta High Court and the date of the judgment is 2nd August 2023. The facts of the case are like this. In the present case, the assessee did the substantial expansion in the assessment year 12-13, and so the assessee was eligible for 100% deduction under section ATIC. The assessing officer did the assessment for the assessment year 12-13, and in the same manner the assessee claimed the deduction under section ATIC at the rate of 100% for the assessment year 13-14 and 14-15. But only for the assessment year 13-14, the Principal Commissioner of Income Tax initiated the revision proceedings under section 263 on two grounds. His first ground was that there was no proper inquiry by the assessing officer, so the order is erroneous. And the second issue was that the assessee has not submitted the form 10CCB during the assessment proceedings. But the facts were different. The assessee has already filed the form 10CCB both at the time of the original assessment and at the time of revision proceedings also. But the principal CIT go ahead with the revision and disallowed the 100% deduction claimed by the assessee under section ATIC and restricted the addition to 30%. When the matter came to the tribunal also said that since the assessee has not submitted the form 10CCB, so the deduction should not be allowed. But the facts were totally different. The assessee has submitted the form 10CCB at the time of revision proceedings also. The assessee moved to the High Court. The High Court said that in the present facts and circumstances, the first allegation that the assessee has not submitted the report in form 10CCB is false, and the assessee has already submitted. So on this basis, the deduction at the rate of 100% cannot be denied to the assessee. And the second point which the court said that when a matter has been adjudicated in favor of the assessee in the assessment year 12-13, that was the preceding year, and in the assessment year 14-15, that was the succeeding year. So only in the mid-year, that is the assessment year 13-14, the order cannot be said to be erroneous, and it cannot be blamed on the assessee that the assessee has claimed the ATIC deduction not as per the law, because the department has taken the stand in the assessment year 12-13 and 14-15 that there is no issue in claiming the deduction by the assessee at the rate of 100% under section ATIC. So in the mid-year, the deduction cannot be denied to the assessee at the rate of 100% because the substantial expansion was taken by the assessee in the assessment year 12-13, and this was the second year, that is the assessment year 13-14, in which the assessee was eligible 100% deduction under section 80 IC. At the end of this video, once again I am repeating the name of the case. The name of the case is C&E Limited versus Principal Commissioner of Income Tax, and this case has been reported in 460 ITR at page number 13. The matter has been decided by Honorable Calcutta High Court, and the date of the judgment is 2nd August 2023. Thank you, friends.